Good evening, everyone. It's my pleasure to welcome you all to the seventh lecture in the first webinar series conducted by Vivekananda College of Law, along with its alumni in association with IQAC. I request today's speaker is Mr. Siddharth B Muchandi. He's an advocate and alumnus of Vivekananda College of Law. The topic which he has chosen is the white-collar crimes. I request Dr. KB Kempegoda, Principal of Vivekananda College of Law, to welcome the gathering.
Thank you, Anil. Good evening, friends. I feel it's my pleasure today to welcome all of you on this webinar series. This is Janata Education Society's Vivekananda College of Law. As an IQAC initiative, in coordination with our Alumni Association, we have organized this webinar series wherein we have identified our alumni, those who are excelled well in their own respective field, to educate us on the different topics. As a part of it, we have amidst us today my young friend, Shri Siddharth B Muchandi, an advocate and founder of law firm Muchandi and Company. I take pleasure to introduce him to you all. Shri Siddharth B Muchandi graduated from our institution in the year 2005. I still remember he was adjudged as the best outgoing student of that year. Thereafter, he did his master's in commercial laws. He enrolled in the year 2005, and from past 16 years, he has been handling several cases, including civil, criminal, in High Court of Karnataka and other courts and tribunals in Karnataka. On the criminal side, he specializes in penal laws, anti-corruption laws, cyber crimes, corporate frauds, sexual harassment, and he has handled prosecutions and defense of renowned politicians, corporates, and individuals in matters pertaining to denotification fraud, finance embezzlement, mining-related frauds, and CBI prosecutions. His civil property practice includes property, succession, arbitrations, land revenue, acquisition, trademarks, and he has been advising corporate companies and developers for various issues. He has also been advising banks and financial institutions for title due diligence and real estate transactions. He is invited by police department, banks, and education institutions to conduct seminars, impart training, and also to judge various competitions. He is a cricketer in his cricket club team, Juris Warriors. He is also an avid traveler and likes sketching in his leisure. Siddharth, it's my privilege and honor, because our own students are excelled well in their own field, gives us maximum satisfaction. And with this brief introduction, I welcome you. A special welcome is reserved to you for today's webinar.
Thank you very much.
Welcome, Siddharth. Thank you. And we have amidst us the office bearers of Janata Education Society, members of Managing Committee, and members of Janata Education Society. I take pleasure to welcome all of them to this webinar. We have amidst us office bearers of our Bangalore Bar Association, particularly Shri Shivamurthy, Treasurer of Bangalore Bar Association, is amidst us. I take pleasure to welcome you, sir. And I also welcome all legal practitioners, academics, and students, friends from other institutions, as well as my institution, my own colleagues. I am also eager to listen to my friend Siddharth Muchandi. I take pleasure once again to welcome all of you to this webinar series. Thank you, one and all.
Thank you, sir. Before we proceed, I request all the participants to fill in the Google form which has been provided in the chat box so that you will be entitled for these certificates, e-certificates, which will be provided subsequently. And also request all the participants to subscribe to the YouTube channel of Vivekananda College of Law and share the channel and view all these. The entire lecture series is being broadcasted in the YouTube channel. May I request Muchandi sir, Siddharth Muchandi sir, to take over the session. Also request all the participants that the session shall be for a period of 45 minutes, and thereafterwards 10 minutes will be question and answer session. You can post your questions in the chat box and we'll take up those questions. Thank you. Siddharth sir, over to you.
Thank you, Anil. Thank you very much. Thank you, sir, for the very good introduction. Indeed, it's my pleasure and also an honor to be part of this beautiful webinar series, which has been conducted and which has been organized by the Janata Education Society and Vivekananda College of Law in association with our alumni and other members and the staff and the technical team who have actually worked very hard. We know that the effort that has gone behind this organized webinar series. So I take this pleasure of conducting today's webinar. The topic for the day is assigned to me is white collar crimes. I'd like to share a PowerPoint presentation along with my talk. First and foremost, to understand regarding the white collar crimes, we need to understand the different types of crimes that we have in the society. To be very broadly classifying them, first and foremost, we have these violent crimes, which is the nature of assault or murder or rape that we see in the normal course. Then we have the property crime, which is pertaining to the frauds and forgery relating to a property, where a person is trying to cheat another person by creating fake documents or making forged documents and concocting documents. The third category, if I may say, is organized crime, that is forming a gang, which is punishable under the COCA, MOCA, and the other Organized Crimes Act. And the fourth concept is called as a consensual crime. Under this category, we have offenses such as prostitution, gambling, pornography. So this is also one of the thing which is increased in the last few decades. The final fifth category, which is the most dangerous, if I have to term it as, is the white collar crime. So I'll be dealing with the concept of white collar crime. What is the meaning of white collar crime? How has it emerged over these years? What are the laws which are pertaining and applicable to the white collar crimes in India? What are the various committees which were formed? And whether these committees, what reports have been submitted by this committee, how they are effective, and what are the agencies that are there which are helping us to curb and control these white collar crimes. Foremost, I would like to just narrate what is the meaning of a white collar or white collar crime. So the employees who are spread across various areas, various institutions or organizations, they are categorized under various class based on the nature of the job they are taking up. Now, the employees who are earning higher average salaries, they are doing highly skilled work, they are in office jobs and managements, those who don't get their hands dirty, these are generally termed as white collar employees. And the offenses which are committed by these white collared employees are called as the white collar crimes or white collar criminals. Otherwise, other categories are you have blue collar, the manual laborers who are involved in the unskilled labor, or the persons who are employed in some factories or industries where they are doing the manual work. So we are now talking only about the white collar criminals, who are the persons who are earning high salaries and engaged in highly skilled work and in the job management or the office jobs kind of thing. The first ever case which was reported with regard to white collar crime dates back to the year 1473, which was with England, where an agent was entrusted with the work of transporting wool, and it was found that the agent was stealing some wool while he was transporting it. That was the first case which was found in England, and 1473 was the first instance from where this concept of white collar emerged and it began. Thereafter, in various countries, in various regions, the concept of white collar has gone on to increase, and it's been given a different meaning and conceptualization, and it has changed. Now, coming to the kinds of white collar crimes that we have. On your screen, you can please refer. That is, the broad classification of the kinds of white collar crimes are, first and foremost, the bank frauds. Second is corporate fraud. Third is Ponzi schemes. Fourth, bribery, bankruptcy fraud, insider trading, counterfeiting, espionage, that's spying, money laundering, tax evasion, and finally, medical fraternity or the medical field. So here I would like to just, with the short time that I have, I try to explain these concepts and give certain examples or some case laws wherein these concepts have been dealt by our courts and the laws pertaining to these particular offenses. First and foremost concept is the bank fraud. Bank fraud, we have these commercial banks who are sometimes the employees or the higher management persons are employed in certain false representations to the customers or to the other banks during the course of their commercial transactions. It could be a simple issue related to a bouncing of a check, or it could be a securities issues. It could be any kind of issue where a bank or the bank employees or the senior officials are involved in the fraud, which is called as a bank fraud. One of the issue, which is famous issue, is Sahara versus SEBI, which was in the year 2012, where we saw that the company was providing misleading information with regard to the prospects of the company. And several complaints were filed in that regard before the Supreme Court by the investors. And thereafter, the investigations were conducted and the petitions were heard. And finally, the court ordered for refund of almost rupees 5,120 crores in that matter. Second, very important, there are in fact several judgments on this, several scams and judgments on this line, but I try to cover up as much as I can within the time. The second aspect, as we know famously, is called the PNB or the Punjab National Bank matter involving Mr. Nirav Modi, where the fraud transaction value of was about 11 crore rupees. And this happened in the Mumbai branch of the PNB bank. And there is something called as a buyer's credit. There's an instrument called as a buyer's credit, wherein will be obtained by the local bank's foreign branch for the import of goods. When the supplier who is outside India, he completes a contract, he sends an invoice of the order for processing the payment. And there, the importer has to obtain a buyer's credit. This is the concept which is prevalent in the market when the question of your import is concerned. So in such concept, this buyer credit concept is going on, and the offenders, the accused, took advantage of the situation, and they knew certain loopholes in the system. So what they did was, for in such event, when there is also a requirement that a local bank issues a LOU, it's a letter of undertaking to the foreign bank. Now, this accused, what he did is he colluded with the bank employees, officials, and they started creating fake LOUs from banks. And there, the buyer's credit was wrongly encashed, and huge funds were misappropriated, and the bank was defrauded. And then, when the bank ultimately came to know about this huge loss which was caused, then complaints were filed and the criminal prosecution was launched. So this is one of the example of the bank fraud, which is the nature of a huge loss caused to the not only the bank but also the public money is getting swindled. The second category is the corporate fraud. In this category, it is about falsification of financial information, or it could be a scheme which is designed by the corporates to conceal some important aspects, or to do some fraud and conceal it from the concerned authorities. They also dupe the regulatory bodies such as the Securitization and Exchange Commission or other commissions and institutions like RBI and other important commissions by disclosing some very vital and important information that they're supposed to disclose. And in that process, they cheat and enrich illegally themselves by making such fraud. One of the important judgments in this thing was the Satyam Computers fraud. You might have all heard about it. It's a Hyderabad-based company where it was actually one of the leading software companies and the computer company who was growing every day. It was becoming one of the very popular and highly reputed companies. In that process, they wanted to invest on more lands, acquire more property. Then what happened? In that process, they wanted a lot of liquidation. They wanted money, for which they started manipulating the books of accounts. And they started misrepresenting the financial statements. And they made such representations to the board, to the stock exchange, regulators, investors, and other stakeholders. And they start deceiving all of them. By misleading all these things, they started to bloat up and started selling the shares. So this concept, this again was came to light, and when people and the investors started to realize that there's some kind of fraud and monies have been swindled, then complaints were lodged and the prosecution was handled. And this was a concept which is to be seen, and apart from the IPC, even the SEBI Act, the Act was also brought into picture. Then the third category is the Ponzi schemes or the Ponzi schemes, which is also becoming very a popular kind of a scheme, which is a scheme, or you can call it as a scam also, that many people, like many individuals, are forming companies or proprietorship concerns, and they are luring, they are attracting different individuals to invest monies into these companies. These are more like investment schemes where they ask the investors to invest money, and without risk or with very little risk, their returns will be too high, like doubling of the money or paying very high interest rates, which other banks or any other NBFCs will not be able to offer. Such kind of offers have been given, and that will actually go on fine. There will not be a problem, or it will not have any issues for some time. But after, suppose there are 100 investors, and over a point of time it becomes 200 investors, 500 investors, 1,000 investors. So there is a good inflow of cash. The money keeps coming in, so there's no problem for this company to pay that money to that particular the investors who have come in the beginning. Once the new investors stop coming, then automatically the money inflow starts getting stopped, because of which then the whole scheme will fall apart. It will fail, and they stop paying the whatever interest has been promised, or whatever doubling of the money was promised. Everything goes haywire. Therefore, they stop paying that, and then this public comes to know that it is not a proper scheme. There is some kind of element of fraud in this, and therefore we have to lodge complaints, and several complaints have been lodged. One such very famous scam which we recently saw is a matter of the IMA scam, the I Monetary Advisory scam, wherein we saw that about 40,000 investors across Karnataka and some outside Karnataka also invested on this scheme, and there was investment to the crore of almost to the tune of about 4,000 crores as investors. And and it was also a jewelry thing which also store which was operating, and this scheme where monies were to be doubled, jewelries to be given as against a particular scheme, and all this. And when this scheme fell apart, we saw that all these persons who had lost money, then they started becoming aggressive. They came and ransacked the offices and the houses, and 40,000 complaints were given, and they had to have special counters for receiving such complaints, because the police station were flooded with the investors who had to come. So this is the effect of such kind of a Ponzi scheme. Apart from that, we have other schemes such as the ambident scheme and other schemes which are popular in Karnataka, which have also seen such kind of a issue and problems in Karnataka and several other states also. The third important category of thing is the bribery, which is the most dangerous or the very largely practiced white collar crime, if you have to put it that way. It's bribery. Bribery, there is a person, especially a public servant, demands for money or some kind of a favor or some valuable thing to get some other person's work done. So he is in charge or control of a particular work which is pending on his desk. Some file is to be moved, some order has to be passed, some processing has to be done. So for that, when the person approaches saying, please process my file or give us some kind of a relief in this matter, pass some order, whatever it is, then they start saying, okay, if you pay me this much money or you do this kind of a favor, we will clear this file or pass this order. So it's a bribery, and there should be a demand and acceptance, as we all know, which is punishable under the Prevention of Corruption Act under Section 7 and Section 13 of the PC Act. And we have seen several schemes, several scams throughout India, which have come to light, and some of them have been, convicted. Some are pending for prosecution. Some have got a clean sheet because of various reasons. And one of the famous scam was the Bihar fodder scam, which surfaced in the year 1996. There we saw embezzlement of government funds amounting to rupees 950 crores. This is what we are talking about, 1996. And the allegation of the prosecution was that the department supplied fodder and medicines and artificial insemination instruments for livestock. And the supply was less than what was shown on paper. Therefore, once the investigation was done and the reports were filed, it came to surface, and then even the chief minister of the state was involved, and the matter was investigated and the reports were filed. The second, which we saw, similar thing was the Augusta Westland chopper scam, where we saw that bribes were paid to middlemen. There were also politicians involved in this scam, where to buy 12 Augusta Westland helicopters. This is an Italian defense company, defense manufacturing company, which is called Finmeccanica, which is estimated cost of rupees 3,600 crores was the total budget. And there, several politicians were involved, the bureaucrats were involved, and they had accepted allegedly bribes from several persons who had promised to get these helicopters. The whole concept of this offense was, the modus operandi was that originally, as per the IAF, Indian Air Force, there was a particular ceiling, operation ceiling, and the maximum altitude at which the helicopter could fly, and there were certain parameters which were given by IAF. But because of this intervening of these middlemen, the persons who had got themselves involved in this fraud, they had taken some kickbacks, and they reduced this operational ceiling of the helicopters from 6,000 meters to 4,500 meters, which was completely against the IAF's norms and requirements. And therefore, kickbacks were received, and that came to surface, and investigations were done. And it was found that there was a, in fact, a fraud committed, and therefore the investigations were carried out. One more important matter was the case of Jayalalitha, the former chief minister of Tamil Nadu. Also, we all know that amassing of illegal wealth by her and her aides were all seen. And there it was tune of rupees 293 crores. And basically what happens is, in the case of Prevention of Corruption Act, where it is called as a disproportionate assets matter. One is a trap where the person is caught taking a bribe. But in the case where disproportionate assets are concerned, where a check period is taken for a particular period of time, and if the known source of income and the assets which is the person is amassed, being a government servant, that is disproportionate to that income, then a prosecution is launched under the PC Act. And in such case, it was found that this is very disproportionate to what her income was, and prosecution was launched. The matter incidentally was tried before a special court in Bangalore, who had convicted. Later, the High Court of Karnataka, the accused were acquitted. But the Supreme Court again reversed the finding of the High Court and convicted, and ordered for imprisonment as well as penalty, which is a very famous matter, as we all know. Apart from that, we have also seen several scams in Karnataka, especially with regard to the land denotification, where several bureaucrats and the politicians were involved. Then we have the mining scam with the areas around Bellary, where the entire lands were, the forest land encroachment, the land boundary being encroached and all that, illegal transaction and illegal extraction of mine, all these. And there was a report of the CAG which was submitted to the Honorable Supreme Court, and based on the Supreme Court verdict, then the criminal prosecutions were lodged before the CBI. In fact, I was part of one of the matters which was being tried before the CBI court, and the matters, some of matters are still pending, some have been concluded, and there are also issues of other issues such as the sanction and other matters which were all canvassed before the court, and they were prosecuted. The other concept of white collar crimes is also the bankruptcy fraud. As we all know, the word bankruptcy is a person who is bankrupt, who has no source of income or no property. He can declare himself to be a bankrupt, and the person, he's burdened with huge debt, and he's unable to pay off his debts and all that. So he files a bankruptcy petition, insolvency petition, and he says that I cannot pay. So in that case, how will a person who is lent money, or a institution who has lent money, how will he recover the money from such kind of person? Is another concept which is part of the white collar crimes. Then we have a concept of insider trading. This also is a concept which many people did not know until the 1990s, which happened, a very famous incident in 1990s, which surfaced. Insider trading, to be just to explain the concept, is trading done with the benefit of trader possessing material and non-public information that gives him an advantage over the financial markets. So there is a person who knows certain information about a particular company, and he kinds of gets that information either illegally or through some other source, and he knows that this change is going to happen, and therefore he either invests himself in the shares of that particular company, buy stocks and shares of the company, or ask someone, gives that information to someone else who will start investing, and thereby what would happen is the value, when the market goes up and the values goes on increasing, that artificial kind of a thing is created, demand is created, and the shares have been manipulated. So this very famous matter was one case of Harshad Mehta versus CBI, which surfaced in 1992. He was called as the big bull of Bombay Stock Exchange, where he fooled many investors by taking advantage of the loopholes in the concept called as a RFD, that's a ready forward deal, in the stock market system. He misled several banks and manipulated the information, and he was instrumental in increasing the share prices of one ACC cement, which was 200 rupees, to 9,000 rupees within a span of 2 months. And this kind of an artificial growth or movement was never seen. It was the first time in the history, and that was kind of shocker. After all these things happened, suddenly we saw that the Indian stock market crashed really badly. Thereafter, the fraud surfaced, and there were also fake documents created, fake letters and credits were created, manipulated, and it was an artificial thing which was created by he and his group, which kind of led to a bank fraud and the stock market fraud. And when it surfaced, he was arrested, and there were more than about 600 civil petitions and 70 criminal cases were filed against him. And also the SEBI banned him for trading from the stock exchange for the rest of his life. The other concept is counterfeiting. Counterfeiting, as we know, is making or creating fake currency. Now, here the concept is not only an issue to the country's economy, it's also giving an advantage or giving some kind of leverage to the other offenders who are kind of waging wars against the state also. So it is giving advantage or giving a platform to the persons like terrorists to involve in such kind of activities by creating fake currencies. Though the concept is that they use laser printing technology, other technologies, where the higher currency denomination notes, like the 2,000 rupees or 500 rupees or the old 1,000 rupees, were all counterfeited, and they were made into bundles and they were circulated within the market, especially the banks and other financial institutions. When you get circulated, you will not be able to track unless actually it is scanned in a particular scanner machine. So this also was surfaced, and it is now part of a thing that sometimes when you get into have a bundle of 1,000 or 2,000 notes, you can sometimes find a fake currency, and then you'll have to give a complaint or take an action on that. Then the other concept is the espionage or the spying, where the agents of a foreign government is planted in a particular country to obtain sensitive, confidential data or information of a particular country. So there is a chance where he is coming and staying in a particular company, in a particular country or a particular city, and is trying to gather vital information from the particular department or agency without the knowledge of obviously the company or the country. And thereby, after gathering this information, he sends this information to his parent company or to pay the country, and that will give a lot of security and confidential information, which will cause a breach of the confidentiality and all things. And there's sometimes very sensitive information which will cause a issue to the national security also. One of the famous case in this espionage matter was the ISRO case, which surfaced in 1994. There were allegations of transferring certain confidential documents by the Indian Space Research Organization to foreign countries, and 2 scientists were named and others were also named. And this investigation was done. The police filed a report. Then the courts also conducted a trial. After that, they found that it was in fact a false case, and the accused were acquitted. It's a case where the government, the Supreme Court, ordered for a payment of rupees 50 lakhs compensation to the former ISRO scientist, that is Mr. Nambi Narayanan, that it had the investigation was totally false and farce. It was not carried out in a proper way. Several loopholes were there, and it amounted to harassment to the accused, and such a huge amount of compensation was ordered to be paid. Then the next concept would be the money laundering concept, wherein large amounts of monies which are in cash are funneled to several accounts, and they ultimately routed this cash to business accounts, and they convert this black money or the cash amount into white money or the legitimate accounts. So this get intermingled with genuine revenues, and they will not be able to identify where the source of this particular money has come from. That has also caused loss to the exchequer, and they're not been able to track this kind of a issue. Then the concept of tax evasion, as we all know that every person who is earning after a particular slab is supposed to pay taxes, but they do not pay taxes. They are not honest. They don't show their incomes. They don't show their collections. They show lower incomes than what they have actually collected. They violate certain important rules. They inflate the expenses, and all these kind of active conciliation of the important information. And so they have recently seen a lot of such thing. One of the ministers of the state also was involved in such kind of issue, and prosecution was launched, arrest was made, and all that. And the next concept would be forgery. Forgery is creating of a false document or an electronic record. So as we know, in several institutions, it could be in a matter relating to a private contract or a government contract or a private some kind of a tender issue or whichever issue, where the documents are manipulated, signatures are forged, fake documents are created by the accused, and they are presented as if they are genuine. So this is covered under the IPC, which is section 463, 465, 468, and 471 IPC. So creation of the documents, what kind of effect will that have on society? Is that the documents which are not originally there, or the documents which are supposed to be there, are suppressed or hidden, and fake documents are generated and produced, which will have a lot of serious implications, not only on the matter of properties, finance, but also individually, and a person's reputation also could be at stake in such kind of matter. The matter of in Karnataka was regarding the stamp paper scam, which we saw. That is Abdul Karim Telgi case, where he and his aides were had the modus operandi of printing fake stamp papers in connivance with several government officials and politicians. They prepared such fake stamp papers, and they started selling them to banks, stock brokerage firms, insurance companies, and all that. So when these started spreading everywhere, then they started doubting the genuineness, because what was sold, that kind of amount was not collected in the treasury. So there is an imbalance with the collection as well as the thing. So thousands of crores of stamp papers were created, concocted, and they were sold. So when this surfaced, the criminal prosecution was launched, and he was tried in several criminal matters, and he was also convicted, and the prosecutions were confirmed. Then the other kind of white collar crime, the very important concept which we have been seeing nowadays, is the fraud in the medical profession. So we have been seeing that there are several medical hospitals, it could be, or it could be clinics or individual doctors and other persons who are practicing medical profession. They are indulging in unethical practices and procedures. So there could be an issue of issuing fake medical certificates, post-mortem reports, carrying illegal abortions, giving misleading and fake advertisements regarding treatment of a particular illness which is incurable. They'll say that they will cure by this particular medicines, and after that, sex determination, which is also an offense, which is penal, and in spite of that, they do a secret sex determination. Running scandals, rackets of the organs such as kidney or any other kind of organs. Then also practicing medicine for what they're not qualified. For instance, if a person who is qualified with your Ayurveda or homeopathy, he prescribes allopathy medicine. This kind of practice also is not entertainable. That's basically an offense which is made penal. To check all these things, we have several laws which have been enacted, which have be there in in India, and I'd like to share the laws on your screen, which are relevant. There are several other laws which are also there, but the relevant and most important one I'm sharing on your screen, which is the Indian Penal Code, Prevention of Corruption Act for the bribery part, Money Laundering Act, SEBI Act, and Import and Exports Control Act, FEMA, Companies Act, Information Technology, Securities and Contract Regulations, Foreign Control, Industrial Development Act, and Black Money and Fugitive Offenders Act. So under this, if you have to see, the relevant provisions are under the Indian Penal Code. Predominantly, we have Section 420 and other offences, which is regarding the cheating, and also we have Section 465, 471, which are pertaining to the forgery, 403, which is breach of trust, and misappropriation and breach of trust, 406, and all these concepts which are made penal under the Indian Penal Code. Section 7 and 13, as I said, on the Prevention of Corruption Act, pertains to the bribery and misconduct by a public servant. Then we have Section 24 of the SEBI Act, which is the year 1992. The amendments were made. It is made penal to the extent of 10 years imprisonment, and also the penalty with to the extent of 25 crores. Then we have other acts. Even the Companies Act have been amended to make a lot of penal provisions. And we have the Fugitive Economic Offenders Act in 2018, wherein we saw that offenders like Nirav Modi and Malya, who have gone out of country and not able to think in spite of getting the warrants and also extradition and all that. So we have been seeing that these laws have been implemented and they have enforced, and we are trying to get these offenders back to India. But because of some reasons that they are either getting those bails from those courts and getting the warrants stopped or paused, because of that reason, we are not able to get the offenders back to India. Then I would also bring to your notice about the various committees which were formed in India, which mentioned about the white collar crimes. It originally began with the Shantanam Committee report in the year 1972. Then we had the Lentil Committee report in the year 1986. Then we had N.N. Vohra Committee report in the year 1993. These are principally the three most important reports, the committees which were formed to inquire into the white collar crimes. And what these committees did, and what these committee inquired into. I'll just briefly summarize it. The Shantanam Committee report was the first committee which was formed for the concept of white collar crimes, which was acknowledged in the year 1972 by the 29th Law Commission. The committee investigated and made a report with regard to setting up of a vigilance cell to inquire into such special offences, because they thought that this was to be kept aside, kept away from the normal IPC offences and other offences. Therefore, they required to have a separate vigilance for checking and controlling this kind of issue. Then we have the special police establishment which has to be established for curbing and checking on such kind of white collar crimes, is what the report committee said. Then they have to have some changes in the law with regard to the white collar crimes, and then examination of law with regard to disciplinary proceeding, because apart from having your penal provisions, what happens to an employee with regard to his work, with respect to job, that also has to be seen. So this committee specifically emphasized on the fact of having disciplinary proceedings within the department, holding an inquiry so that these people do not get away with the very mild punishment, or they get an acquittal in your criminal prosecution. That doesn't mean that they are absolved completely. So disciplinary proceedings have to be initiated, and they have to be either their service has to be terminated, or they have to be placed on suspension, or at least their benefits have to be cut, or not be paid to them. Some kind of such punitive action has to be imposed. These kind of suggestions were given by the Shantaram Committee report. Then the second committee was the Lentin Committee in the year 1986. This was pertaining to a particular matter which happened in the year 1986. There's a hospital called JJ Hospital in Mumbai, and suddenly 14 patients died in the hospital. And then when the investigations were made, they found out that adulterated glycerol was used, which was actually not meant for medical supplies, but it was meant for industrial supplies. And illegally, or due to some reason, these particular glycerin was supplied and it was administered to the patients, which caused death of 14 patients. And then when investigations were made, they found out that it was not a small issue, but it involved a nexus between the politicians, the Food and Drug Administration, that is FDA, and the other drug health minister and all that. And because of which the health minister, the then health minister, took onus and he resigned from his position in the year 1986. Then the third committee, which was a very important committee, which is in the year 1993. It is by the former Indian Home Secretary, that is Mr. N.N. Vohra, who had this committee, who chaired this committee, and he submitted the report. There the main thing was studying the problem of criminalization of politics and nexus among the criminals, politicians, and bureaucrats in India. This was a very comprehensive and vast study which was taken by the committee, and they discovered several aspects. Because what had happened is, when the concept was in 1972, before the Shantaram Committee, that concept was different, but the more important years is different. And after the 1980s and during the 1990s, a lot of things had changed in India drastically. And we had seen a lot of influence of these gangsters and the persons from outside India, like operating from Dubai and Saudi and other countries, who had started having a lot of impact on Indian economy, on the politicians, and the other thing like having ransom money and the hafta and all these concepts had started to began in the year 1980s and 90s. So this problem was studied. Then what they found out is that there was a network of criminals which was virtually running a parallel government apart from what the government was there in the country. Then these gangs had enjoyed patronage of the politicians. They had given all kind of protections and all kind of matters. They were indirectly or directly involved. They had become leaders of the gangs, and these leaders started to participate and get elected in the elections of the local bodies, state assemblies, and the parliaments. This surfaced by the investigation, and they also saw that there were a lot of links and activities to the Dawood Ibrahim gang and which had come to surface after the bomb blast which happened in Mumbai in the year 1993. So by virtue of this, what they were trying to do is, by using the money power, by using the muscle power, they developed a network, and they started to put their persons or start controlling a politician during the elections, and they started to manipulate and manage things at the higher level, at the political level. And one important aspect also was covered is the mafia boss, which is Iqbal Mirchi, was just an ordinary person who was trading into a smaller trade. Then suddenly we saw that he grew enormously, and he started making a lot of money, started investing a lot of properties, crores together, he started making money. So he had that was a person from whom the mafia giant started to come to surface, and they started becoming a gang. So they started becoming a criminal gang. There were armed senas, drug mafias started to surface, smuggling gangs started to surface, drug peddlers, economic lobbyists, all these kind of different concepts which are not new, which were not earlier prevalent in India. They started to surface in India, and these were all the concepts which were found by the committee. Then they also started to form crime syndicates, and they started started to have a significant impact on the elections and other bureaucrats in the states such as Bihar, Haryana, and UP. Then after this was controlled, and this was handled to a certain extent, and it was controlled, then they started shifting their focus on other areas such as narcotic drugs, weapon smuggling, and terrorism networks, and all these things. Then they started to focus on the states of Jammu Kashmir, Punjab, and other states. So then we have the next title, which is the agencies which are there to curb the white collar crimes. So mainly we have these important agencies in India which are effective, or which to curb and to control the white collar crimes, which is a Central Board of Excise and Customs, Central Board of Direct Taxes, Central Board of Intelligence Bureau, the Enforcement Directorate, or the ED we call it, NCB, Narcotic Control Bureau, and Central Bureau of Investigation. So the role of each such thing, I just like to very briefly explain. I understand that there's a paucity of time. I will not take more time on this. But just to briefly say, is that the CBSE is the Central Bureau of Excise is there to prevent smuggling and other also to control avoid customs, evasion customs, and other duties. The Central Board of Targeted Taxes, as we all know, is Income Tax Department and other wealth tax department. All these is to control the tax part of the country. Then we have the Central Economic Intelligence Bureau, which is for the purpose of coordinating, strengthening the intelligence gathering activities to control and stop the economic offenses, the enforcement, and all that, and to curb black money in particular. And the fourth agency is Enforcement Directorate, to investigate into and to punish and to the especially the aspects of Foreign Exchange Regulatory Act. Yeah, it was FERA earlier, now it's become FEMA, to collect all the data pertinent. Then we have the NCB, which is the for the narcotics, drugs, and psychotropic substances. And obviously we have the CBI, which has various kind of things. Under CBI, we have different cells like the fraud and the other matters where they have been bifurcated, and these departments takes up the issues of controlling and managing things. The last aspect which we are like to cover is the measures to curb the white collar crime. Under this, we have various concepts which already the committees have advised, which is enacting stringent laws in India, equipping the investigating agencies, specialized trainings, increasing the special courts, spreading awareness amongst the employees, among the public servants, and the public in general, transparency in systems, and encouraging whistleblowers. In this, I would like to just briefly narrate is that laws are there, which are like as we discussed, Indian Penal Code and the Prevention of Corruption Act, among several acts. But certain places we see that the punishment is being imposed or it's been provided is very, very less. So that kind of gives a leverage, or do you think that it may not be a very strong thing because the penalty is very low, the fine is very less. So we require that the laws are made more strict. Then equipping the agencies, like giving them the latest technology, giving them the funding, giving the staff and other things. Then we have the transparency, that we have to have transparency in giving this very ethical and suitable framework amongst the agencies and the government bodies, so that there is so to this effect we have this Right to Information Act, which was enacted in the year 2005, so that the person, the public, knows what's happening, and they are transparent, and they are made to be accountable for what is happening with them. Then the specialized training has to be given to these officers to make sure that the techniques and the things are used properly, they're not misused. And encouraging whistleblowers is one concept which is more prominent in the countries like US and UK. But in India, we do not see it in a very serious way. In fact, we kind of laugh it off, or we take it as a joke that RTI and he's an RTI activist and he will just create some kind of a thing and it will not be taken up so seriously. But encouraging whistleblowers in the right way, that is very important. That from government there should be some initiative to take and to give some benefits to such and protections to such whistleblowers, and keeping them under some kind of a secret thing, not bringing their names across, so that they are not scared or they are not exposed to that kind of a threat or any issues, or being tampered with at the stage of trial or any kind of thing. These are the concepts which will help us to control and monitor the concept of white collar crimes. Then the last important concept is the spreading of awareness, because unless the people are aware, that the common public is aware, the officials are aware. Obviously, the officials and the public sector employees, they're not. It's not that they are not aware that getting into such kind of practices is illegal. But yes, but they say that's a matter of practice. Ellaru ಮಾಡ್ತಿದ್ದಾರೆ, why should not we do it? It's a common tendency. But the effect of this, what is the effect of this? What are the laws in place? What is the penalty? And what will the repercussions on the individual per se, on the institutions, and also on the public at large has to be made aware to those individuals, whether it is a public servant, whether it is a other employee or person who is doing in a trade or some kind of a stock broking, or as I said, a doctor or any person for that matter. Unless this awareness is there amongst the persons, then these kind of offenses cannot be controlled and it cannot be curbed completely. So with this, I would like to conclude my session. And if there are any questions, Anil or anybody else could please post it to me. I will be happy to answer.
Thank you, sir. Thank you. The topic was very well explained. Before I proceed with the question and answer session, I request all the participants to fill in the Google form which has been provided. That is the feedback form provided in the chat box, so that you will be enabled to obtain e-certificates. Now, sir, with the question and answer session, can I take a few questions, sir?
Please.
Sir, several questions have been sent by Mr. Rohit Swami. One among them is that what is the role of statutory auditors in fraud risk management in corporates? Auditor, in the course of performance of his duties, a reason to believe that there is fraud being committed against the company by the employees or the officers. So what is the role of the chartered accountant is what the question, sir.
Yes, that is a very important aspect. And in fact, the auditors or the chartered accounts play a very, very vital role in a company. So in the frauds which I just spoke about, it could be Satyam fraud or any other fraud. We have seen that even sometimes the chartered accountants, the auditors, and even the company secretaries have been made an accused, because it's not that without their knowledge all these things have happened. So they know, most of them know about it. With their knowledge or perhaps with their consent or with their active connivance, such kind of offenses have been carried out or been committed.
Similar such question is being asked by Mr. Sridhar Shri. Probably that would cover your answer would cover this question as well. Mr. Ashok Puja he poses a question stating that, could you give cases of ordinary general public who got the relief with regard to their financial losses? So
Yes.
probably he is referring to these Ponzi scams or such other things.
Ponzi schemes, what's happened is, now if you see a few schemes now which have become into scams, are basically the investors, they started filing complaints. And apart from the complaints, they also filed consumer forum petitions and other complaints, and sometimes even the enforcement directorate took over the matters. So, for giving just an example of this scheme of IMA, where the enforcement directorate has seized all the properties pertaining to the main accused and the company, and when they have seized, they have evaluated, and they have found that X amount of, though the scam is totally about 2,400 or some crores, but not to that extent. I think around 800 or 900 crores of properties have been seized. So when these things are seized and the petitions are filed by the particular persons, there are special courts established for that purpose also, which is CBI Special Court has also been given the powers to entertain such petitions for honoring the claims of such investors, and they are allowed to file their petitions with certain what the claims, whatever the monies have lost. Then the courts are there to examine them and pass necessary orders for release or remitting such amounts to such investors who have lost money.
Okay, sir. There is one more question by Kirtana. It says, to what extent is the doctrine of corporate weal applicable in cases concerning corporate frauds or white-collar crimes in general?
Yes, white-collar crimes and the concept of the corporate weal is the one which is very important. It's obviously connected together, because what happens is, in a company, as we say, that the company, the employees of the company, the directors of the company, and all these go hand in hand. They have to have the thing of right from incorporation to the declaration to all such events which happen within the company. That is all part and parcel of the thing. And when the fraud happens within the company, then the particular officers, the directors, the founders, everyone are responsible. So in the event that the fraud surfaces, so the government and the concerned authorities are taking the measures to take those persons, fraudsters, to task. Apart from getting penalized, as I said, they are attaching the properties. The companies are getting wound up in the subsequent years, and all the whatever prosecutions have to be done are being done.
Okay, sir. Pradyumna Ravi has a question. What are the suggestive measures or reforms required in tackling the white-collar crime menace in India?
Yes, as I just summarized a few things, just to reiterate that we need to have stronger laws. The agencies which are already there, they need to be equipped technologically, and the staff-wise, the funding has to be more. All these concepts, and apart from that, awareness and whistleblowing, and all these concepts which I just narrated, these are very essential to see that these things are curbed and also not allowed to grow further.
Okay, any other questions?
Anil sir, Professor Nagbhushan ಅಂತ ಒಬ್ರು ಕೇಳಿದ್ದಾರೆ ನೋಡಿ. It is in the chat box. I have sent it to you.
My name is Dr. Nagbhushan, sir.
Yes, sir.
See, in case of white-collar crimes, sir, that is Mr. Modi and some other persons have escaped from our country. Okay, because the relationship may be different from England to India, etc. But why the CBI is making the delay? Why it is not taking a serious matter than that of the Indian Penal Code offences?
Yes,
if that would be taken as serious one, then immediately the punishment which would be imposed upon the wrongdoers. Suppose, take it for example, the Sujana Chaudhary case is investigated. Later, it is appeared that they will prove that it is not coinciding with that proofs and all these things. How it is happened? Without a primary cause, they won't book the offense. First of all, with primary cause only they are booking the offense. Later, it is said that there is no primary cause. Isn't it, sir? Some evidence is there.
I understand what you're trying to say. So here, what would happen is, now the CBI or whichever investigating agency for that matter will investigate and prepare a report and submit the report. And there could be delays. And we are not saying that there are no delays. And we are not saying that when the CBI is done, it is 100% foolproof or it's perfect. We are not on that. There are cases where CBI has filed a charge sheet, a very detailed charge sheet. Even then, the accuser acquitted. It's ultimately what happens is there are tests which have to be, it has to stand the test of trial, is what we call. Because what happens is, in the case of a criminal matter, as we all know, it is based on beyond reasonable doubt concept. So, if at all there is some element of doubt, and there are other technical glitches also, like what we see is there is a sanction of prosecution, or some technical scientific evidence not available, or some tampering and things happening during the prosecution. All these kind of concepts are available. So CBI per se tries to, as far as possible, complete the investigation, file a report, because we have the best officers in the country who are with the CBI. But inadvertently, or due to some issues, there are certain lapses committed by the investigating agency, like we saw the Talwar's case, where the CBI was condemned. Reports were initially filed, then the CBI took over. All that happened. There are certain lapses, and it's not that every CBI case ends in conviction. I have myself defended a criminal few CBI matters where we got an honorable acquittal, not on question of technicality, but on the merits itself. That the offence is not satisfied, the connection between A, B, and C is not established, and all that. So we have a concept. We are ultimately bound by the books, the CRPC, and it's not only about the IPC or any special statute. You may involve special statutes like the SEBI Act or the PC. Several other provisions are there we have to invoke. But whether those offences fall under the definition of that particular thing have to be seen. So yeah, we have to blame CBI sometimes. We have to blame the court, blame ourselves. We have to tell it is either the stupidity of the investigator or the smartness of the lawyer, or the discretion of the wisdom of the judge. So it could be anything like
that. There is one last question you can take, sir, from Mr. Hemant Kumar. He asked, what are the possible punishments for white-collar crimes? So probably he's referring to this rigorous imprisonment. To what extent can it be?
Sure. So as we say, sir, white-collar crimes they're broadly classified under several kind of things, and we have to see under which particular provision of law that the prosecution has begun. What is the particular act that has been invoked, subsection of law, which was invoked by the prosecution, CBI or any other prosecution, which is made penal in that particular charge sheet. So in that, we could have something from IPC offences to Prevention of Corruption Act, to the SEBI provisions, to any other provisions. So suppose, and as I said about a provision which has section 24 of the SEBI Act, which says up to 10 years, and which may have a penalty of 25 crores, which was never there in any other penal laws in India. That kind of a severe amendment. Now, if you have something like the Information Technology Act, where the punishments are high, and the penalty is like 1 lakh, 5 lakhs, 10 lakhs, and if you compare that punishment to the Indian Penal Code, which is very paltry, which is in terms of hundreds of rupees or sometimes thousands, very, very less, which requires a drastic amendment. So what I'd say here is, irrespective of the offense, what provisions have been invoked by the prosecution, it would depend on that. And ultimately for what offense is found guilty. Suppose cheating and forgery is disproved, cheating is proved, then he'll be convicted only for cheating, and whatever maximum penalty or minimal penalty imprisonment that is provided will be imposed upon that person. Hello, sir. Hello.
Yeah, thank you for a good overview in the shortest possible time. I am on the white collar. See, two things. I have no question as such. Two information for the listeners. One is in the list of laws which you showed, I think you should add IBC also. Because it's correlated to some of the things. See, if you see, before IBC was enacted here in 2016, world's largest individual bankruptcy was by an Indian, a London billionaire Rajendra Singh Sethia, who was arrested in 1985. He was at the same time owning an aircraft with the gold bath tip fittings. He is the man who funded Charles Sobraj to escape from Tihar jail in 1986. He has been acquitted only in 2019. It took 34 years for his acquittal to happen in this country. That is one thing. The other is your Viniving Shastri's case is similar to Ponzai camp. Recently, the government on June 17th, the government has decided based on the High Court's order and High Court questioning why government has not yet attached the properties of Roshan Beg in the IMA matter. I think June 17th, government has asked them to identify the properties that need to be attached in these things. There are a lot of, so even Rajendra Singh Setia was involved in the PNB scam also because his huge billion empire SL Commodities, which were supplying sugar and rice to Nigeria and Sudan, underwent a loss because of the military coup there, and Julius Nyerere, the president, was dethroned. And 1982 scam live, Sony, they have to see, the listeners also need to see this on the OTT to understand that the Harshad Mehta scam. Thank you.
Yeah, in fact, I had a list of several other judgments, right, from your Colgate scam and the 2G Spectrum scam and all that. India is not, we are not short of any such scams in India.
Correct. No, I just thought interesting stories on Harshad Mehta 82 scam is there on the Sony Live thing. YouTube also they can check. They'll understand how this thing happened.
Try to bring it within that 45 minutes.
No, I know. I said let them look at these things to interesting stories on these people who are very popular, infamous personalities in this country. Thank you.
Thank you, sir. Thank you very much. It was a very nice interactive session, and also the session gave a lot of informations. Now, I request all the participants again to fill in the Google form which has been provided in the chat box. Also request the participants to subscribe to the Vivekananda College of Law YouTube channel. I thank one and all. I thank all the participants who are present here and made this event a successful one. My heartfelt thanks to representatives of various institutions, Dr. Narayan Swamy, Principal, Vidyodaya Law College, Tumkur. I also thank Professor Shiv Prasad, Principal, Bengaluru Law College, who was also my beloved professor, I can say my beloved teacher. And Dr. Siddhana Gowda, he's from Bagalkot. Dr. Mohan Bola, Principal, Christu Jayanti Law College. Dr. D.V. Chandrasekhar, Principal of Vivekananda Institute of Technology. Also Professor Jetty, Professor Dr. Nagabhushan, Dr. Sanjeev Gowda, and also thank the office bearers of the Advocate Association Bangalore who are present today and made this event a successful one.
Hello, sir.
Thank the lawyers and other law practitioners who participated today. I also thank faculty, Vivekananda College of Law, Principal Dr. K.B. Kempegoda, Vivekananda College of Law, all the alumnus, and especially the office bearers of the Alumnus of Vivekananda College of Law. Thank you one and all. Madam, I request Madam to share Monday's event, the invitation that is on 5th, 7th, 2020-21.
Hello, sir.
I request all the participants again to be participated. Yes, yes, sir.
Hello.
Yes. Monday program, Anil. Anil, unmute yourself, Anil.
Okay.
Anil.
This is Monday's event. The topic is to pivot or persevere the long march of change in labor laws by Mr. M.R. Ravi Shankar. He is alumnus of Vivekananda College of Law and a practicing advocate. This will be one more interactive session. I request all the participants to be present again on Monday. Thank you one and all.
Hello, sir. I have a last doubt.
Okay, guys, profusely.
I think one person has.
Can
you please leave it in the chat box, sir? Can you please leave it in the chat box? We will answer to your question. Because of paucity of time, we have to end the session. Please leave it in the chat box. We'll see to its answer.
You are not audible. Siddharth, it's a wonderful session.
Thank you.
And we know that it is a and on behalf of our institute, and thank each one of you.
Sir, you are not audible.
The voice is getting cracked, sir.
And make this event and
Anil sir.
I think sir voice is not
Yeah, Bhuvana, you
audible.
can end session now.
Yes, sir. Yes, sir. Anil sir.
Can we end the session?
Yes, sir. Thank you very much, one and all. Thank you. Thank you, sir.
Thank you, sir.
Okay, now, thank you.